getting a lot of questions recently from estate agents, especially around mandatory disclosure forms. It still seems like a bit of a, what's the word? There seems to be a bit of uncertainty around them, where they're required, when they're required, how they're required, all of that. We did answer these quite a bit of times, but there was a question specifically today that came in, basically asking, so the mandate was received with the mandatory disclosure form. Yeah, the mandatory disclosure form disclosed everything that it needs to disclose, but then during the transfer process, the owner of the property realized that one of the buildings on the property had been illegally built, contrary to building plans. So there are no plans for this, right? So now the mandatory disclosure form was signed on acceptance of mandate. So the estate agent feels that they've done enough, because I mean they've ticked that box. Now the deal's going ahead, and the seller feels that they've done enough because at the stage of concluding the deal, they obviously disclosed everything they knew, and they happened to stumble upon this by chance. And now the question is, do they have an obligation to disclose this mid-transfer, or have they done enough already because the sale was concluded on those terms? Because there is a footsteps provision in the contract, and he wasn't aware of this defect. And they want to know, basically, the agent wants to know if it's incumbent on them to advise the purchaser. And obviously the agent also needs to know, if not, is it incumbent on the seller to advise the purchaser? Interesting one, huh?
Yeah, it is an interesting one, but what's you know, the starting point really for it, and what's most interesting is the type of default that we're talking about in the circumstances, because you know, the mandatory disclosure form, obviously we talked about it, it's an important document, it's got to be used in all transactions going forward. That's what the act now says. You know, and I mean the purpose of it is obviously to find defects at whatever sort of level. What's interesting about your particular point that you brought up now is, you know, it's a complete building which obviously wasn't properly you know, approved from the municipal standpoint, which is really you know, as far as defects go, if you're doing a transfer of property, that's probably the biggest one you're going to find. You know, so it's an interesting one because the nature of the defect is so big, and you know, I don't want to make any assumptions on behalf of the seller, or you know, you never know, but how exactly did that building pitch up? And it seems unlikely to me, you know, to assume that the seller didn't know that that proper plans hadn't been given in respect to that particular building. It would be very unlikely, but it's just interesting from a defect perspective, because it's such a big defect, you know, which I think will materially affect, you know, what's got to happen in the circumstances.
Sure. Yeah, no, absolutely. So look, my understanding of the phrasing of the question was, it's an attached building or a separate building, so it's not the main building. So, but to your point, I mean, it is a bit strange that he doesn't know, but I know of a lot of people that bought properties, and unless the bank actually asks for the building plans, they sometimes just buy the property making certain assumptions that aren't there. And I mean, we know the risks of having buildings around without building plans. But yeah, the materiality is very important. And I mean, had the situation existed, or had the defect been known about prior to conclusion of the sale, the answer would have been very simple. Of course, you need to disclose it, because if you don't, it's misrepresentation. And I mean, that opens up the doors for many things. So interestingly enough, so my take on this, and you can tell me whether you agree or not. So my take is, yes, the contract's been signed. Yes, there's a footsteps clause, but in our law, for ownership to pass and the sale to be perfected or properly finalized, there has to be delivery. And delivery symbolically takes place at the deeds office with the movement of the title deed from one person to the other. So my opinion is that whilst you're still in the sale process, if you find something out, you're not going to be able to hide behind footsteps, because it's something that you were aware of, even though the contract's already been concluded, because failing to disclose it would actually be material and would impact the deal. And yeah, it's the deal hasn't actually been concluded yet.
Yeah, I got to admit, in the circumstances where you find something out during the transfer process, especially something as as material as that. You know, if it was a small defect, you know, something that's, you know, cracked tiles or whatever that weren't noticed at the time of inspection and a later stage, that's not a material breach that's going to, you know, that's going to create an avoidable transaction, you know, or avoid transaction between the parties. But something to this extent, you know, and in particular, if, you know, it's come to the knowledge of the seller in the circumstances and they don't disclose it, I think that is problematic, and I think you would definitely have, you know, the ability to, you know, take some sort of legal recourse if that transaction went through, and that that information didn't come to your knowledge. I think would be problematic, really.
So maybe to wrap up the question, what would your advice be to the estate agent, caught in the middle of a defect? They've done their job. Now there's a defect, and they're kind of caught in the middle of the transaction.
Yeah, look. So interestingly, when it comes to the mandatory disclosure form, obviously the requirement for the estate agent is to make sure that it's attached and signed. And it sounds like in this particular question that particular job has been done, which is good. So they've fallen within the ambit of the act. The problem here is how far does the knowledge of the estate agent go, and what can you impute on them as a result of the knowledge and non-disclosure of this particular thing. So where I'm going with that, and this is fairly complex law, but it's something that bears mentioning. You know, when properties are transferred from one party to another, generally there's the ability to set that transfer aside is a rare thing to do. It's very difficult because our law doesn't like us just, you know, not having certainty with who owns property, and this is why we have a great registration system in South Africa that really solidifies passing of a property from one person to another. Courts and the law don't mess with that unless there are circumstances where you can really show, and I mean like fraudulent misrepresentation from one party to the other. And you know, obviously from the estate agent's perspective, they need to be careful as well. You know, there is the purpose of the mandatory disclosure form, if it's not done, they acquire some personal liability, and even if you don't go from the mandatory disclosure perspective, you know, I still think there's an arguable point for fraudulent misrepresentation if the agent has said, well, this house is perfect, knowing full well that there is a material defect to that effect. I think it could draw personal liability just on the fraudulent misrepresentation aspect. So from my perspective, estate agent, I think, you know, guard yourself, protect yourself. You've got some liability in terms of the act, and you've got to look after your fidelity fund certificates. So I would disclose in the circumstances if it came to my knowledge.
And I mean, it'll like to build on that. So I get an argument to say, well, you know, omission as opposed to saying that everything's perfect. I'm not saying everything's perfect. I'm just admitting at this point in time, late stage, to mention something that no one knew about. But so the fraudulent misrepresentation, absolutely. Negligent misrepresentation, but also another interesting one, which I feel is going to start developing. And this is a gut feel, and people might agree, disagree. It's totally speculative. But if you look at the way that the Act enshrines, you know, the professionalism of property practitioners. So attorneys, for example, couldn't get away with that. We couldn't get away with, oh, we didn't say it. But everyone assumes, oh, but estate agents could. But Property Practitioners Act like really takes it up a notch to the point where there is a professional duty, arguably a duty of care. And if you look by the very nature of the provisions and enactments requiring mandatory disclosures, denying agents the right of taking on a mandate without the MDF, it creates this perception that an agent is responsible for taking on more responsibility. Sorry, responsible for responsibility. But you understand what I mean? They are slowly going to end up taking up more professional responsibility and and having to make sure that, for example, because I was having this argument today, mandatory disclosure form. Let's say you walk into the house, you see it's in ruins, and you tell the seller, fill this in and complete it, and he fills it in and goes, oh, whatever, like the cupboard door is broken. And you're looking around going, well, no, that's really not the case. is it incumbent on the estate agent to go, I can't accept this mandate because yes, you completed and signed it, but you're lying, and I know that you're lying. And the Act doesn't specify that because it makes it very black and white. I don't think that's going to fly. But in any case, that's a gut feel. That's speculative.
Yes. Yeah, and look, I mean, it's the interesting thing about this conversation is we keep having it, and there's a lot of development that's got to come in due course. A lot of clarity that we ultimately need, but it will come eventually. So our advice to estate agents is, be careful. We know it's a bit of work, but the point is it's a bit of work, to protect yourselves and the clients as well.
Sure, absolutely. Cool, but thanks so much, Nick. We're going to need to get going. It was a late day today, but have a great one, and see you again next week.
Perfect. Thanks, Bruno.
Cool, cheers.
Cheers.